A key function of the company secretary is to be a trusted advisor to the board of directors of the organization which he or she serves. Hi, my name is Jimmy Walaviechi, and you're welcome to Corporate Governance Africa, where we seek to promote good governance through film. In this video, we consider the function of the company secretary as a trusted advisor to the board of the organization. In this respect, we consider the testimony of Mr. Polani Sokombela, a business executive at the Office of the Auditor General of South Africa, before the Zondo Commission. The testimony concerns the Auditor General's findings of an external audit of the financial statements of South African Airways for the year 2016-2017. In his testimony, he stated that the board had passed certain resolutions which breached the law of South Africa. However, there was nothing to show that the Office of the Company Secretary had advised the board against passing those resolutions. His testimony highlights important matters related to the Company Secretary as a trusted advisor to the board. First, we give a brief overview of South African Airways. South African Airways is the national flag carrier of the Republic of South Africa. Its headquarters are in the Republic of South Africa in Johannesburg. It was founded in 1934 and was then wholly owned by the South African government. For several years, it was the subsidiary of Transnet, a government-owned company, until 2006, when it was split from Transnet, its parent company. From then on, it operated as an independent airline. But in December 2019, the airline entered into voluntary business rescue because it had suffered losses for so long over the years that it was unable to pay off its creditors. The following year, in 2020, it suspended all operation. Later, in June 2021, the government of South Africa announced that it had entered into a partnership with Takatso Consortium, which would hold a 51% controlling stake in the airline. The airline is supervised by South Africa's Department of Public Enterprises. South African Airways is the holding company of some subsidiaries including South African Airways Technical, Air Chefs, and South Africa Travel Agency. But what is the Zondo Commission? The Zondo Commission was a judicial inquiry into alleged state capture in South Africa by some private individuals or entities. It was led by the now Chief Justice of South Africa, Chief Justice Raymond Zondo. And state capture is defined as the illicit control of the state by private firms, individuals, or other entities like the military, by giving private gains to public officials through corruption. In the case of South Africa, the public prosecutor had found that there had been state capture by the then President of the Republic of South Africa, Mr. Jacob Zuma, and certain members of the Gupta family. These findings by the public prosecutor are what sparked the need for the judicial inquiry into state capture. The Commission focused on the practices of executive members of the state and their relationships with individuals, including the Gupta family and its associates. In this respect, the inquiry probed the activities of various state-owned enterprises, including Eskom, the South African Broadcasting Corporation, and South African Airways and its subsidiaries, amongst others. The Commission ran from January 2018 to June 2022. In that time, it heard the testimony of more than 300 witnesses over 429 days of the public hearings. On the 21st of February 2020, the Commission interviewed Mr. Sokombela concerning the audit of South African Airways by the Auditor General. The Auditor General had issued a qualified audit report and noted some internal control challenges in the airline. The Auditor General expressed certain concerns related to the role of the Office of the Company Secretary in the airline. And this is what Mr. Sokombela had to say about the role of the Company Secretary.
I think one of the concerns that we had there at SAA is that the Company Secretary's office is very important, especially in terms of them fulfilling their responsibilities in terms of the Companies Act and advising the board of directors. There's many transgressions that we saw at SAA out of the board resolutions that were made. And we couldn't see where the company secretary has advised the board. If I may make an example, for example, there's an example where we found out that SAA has provided financial assistance to its subsidiaries. the air chefs, the South African Airways Technical. There's another small subsidiary that they have that is called South African Airways Travel Center. They provided financial assistance to that to those subsidiaries, contrary to the requirements of Section 45 of the Companies Act, because Section 45 of the Companies Act requires then a company to prove that after the financial assistance has been provided, the company will meet the requirements of solvency and liquidity challenges. So I think that was a challenge, because at that time that SAA was providing the financial assistance, already SAA was in financial distress. Their liabilities were exceeding their assets, meaning that the SAA was insolvent. They had liquidity challenges, and then that resulted in them, I think, in the Companies and Intellectual Property Commission issuing a non-compliance notice to SAA, specifically for the financial assistance that was provided to air chefs. I think that's the one. So that is one example, Chairperson. Another example is I think there was also a board resolution that was made for the set aside of the 30%, I think, for the SMMEs, which I think the DTI, the National Treasury, have warned the board that this is the decision that the board was making was unlawful. However, the board continued to implement that decision, and we couldn't see how the Company Secretary also couldn't advise the board on that. So those are the examples, Chairperson, to name a few that we had, and that made us then, as the audit team, to be worried then in terms of then what is the value then that the Company Secretary's office is providing to SAA.
From the above testimony, there are at least 5 lessons that can be gleaned from this whole scenario. First is that the company secretary needs to take a proactive role in advising the board on matters related to governance. It would not be necessary for the board of directors to seek advice from the company secretary, for the company secretary to offer their advice under these particular circumstances. The reason is because the company secretary is not a mere scribe in the company, but a senior official of the company who has a voice in guiding the decision making of the organization. Concerning the important role that a company secretary plays in an organization, the celebrated English judge, Lord Justice Denning, said that this company secretary is an officer of the company with extensive duties and responsibilities and is not a mere scribe. Also showing that a company secretary needs to take initiative where advising a company is concerned. It has been said that company secretaries can no longer afford to take a passive stance in the companies and on the boards that they serve. Simply acting as a doorman at board meetings is no longer adequate, and nor is it a defense. And company secretaries who are lulled into a false sense of security do this at their own risk and peril, in case they are subsequently found to be wanting and to be on the wrong end of the law. Second is that the advice includes matters of compliance with policies and the law which apply to that organization. So the Auditor General was surprised that there was nothing on the record to show that the office of the company secretary had advised the board against these transgressions. King 4 explicitly states that the board of a company should ensure that it has access to professional and independent guidance on corporate governance, and that where a company secretary is appointed, he or she should provide such professional corporate governance services to the organization. A third point is that the company secretary, as an advisor to the board, plays a key part in the risk management of the business. The reason is that through their advice on compliance with laws and regulations, they may avoid or mitigate legal risks that the business may face. And when a company secretary does not offer the appropriate advice to the board or to the organization, the business is exposed to these risks. The Zondo Commission expressly stated that the challenges related to the company secretary function with South African Airways presented a risk to the airline. The other important point is that a company secretary ought to put their advice in written form. It's not every advice that would be required to be in written form, but advice of this nature that would have such far-reaching consequences to the company would safely have to be put into writing. It is indeed conceivable that the office of the company secretary of South African Airways indeed gave the advice to the board. I dare say that it's highly probable that they did give this advice. The only challenge is that there is nothing in writing to prove that this was the case. Written advice would therefore be important, especially where there are serious transgressions involved, as was the case with South African Airways. The fifth is that the company secretary may sometimes be compelled to execute their duties in a very toxic governance environment. This is the type of environment or the kind of environment that prevailed in South African Airways at this time. The Zondo Commission observed that the governance procedures at the airline had been dismantled during the tenure of the board chair, whom the company secretary at the time worked with. The report stated that the governance environment at South African Airways was characterized by a climate of fear and intimidation. The Auditor General also observed that the company secretary's office was undercapacitated. Could these factors, the intimidation and the undercapacitation, hinder the company secretary from giving the advice? It's very possible that that was the case. In any event, a company secretary is still expected to be a trusted advisor to the board that he or she serves. In view of these potential pressures, a company secretary needs to develop the fortitude and moral courage to give independent advice in the face of such difficulties. This, of course, is easier said than done, but it is something that ought to be cultivated and strived towards. In conclusion, the company secretary plays an important role as the chief advisor to the business that he or she serves. They ought to be proactive in the advice that they give, and they need to have moral courage and strength, and they need to document advice where they feel that it's necessary to have that advice documented. These are a few lessons that may be gleaned from the whole unfortunate scenario. But if you're a board member or a stakeholder or a company secretary or any other person that would be concerned with this particular matter, what lessons do you learn from this unfortunate scenario?